One of the other issues that we seem to have to deal with quite often is the issue of reasonable modifications and reasonable accommodations. When we are doing rental properties and we have handicapped or disabled tenants, a homeowner or a landlord must allow the tenant to make reasonable modifications to the property. Certainly it's done at the tenant's expense. They have to put it back into the same condition it was in before when they move out. But if that tenant wants to put in grab bars or ramps or lower light switches or do whatever they need to do, the landlord must allow them to do it. They cannot refuse them. Now, the other issue that we deal with is homeowners associations making reasonable accommodations to their rules and regulations in order to allow the tenant the use of the property. So, for example, and this might not only just be homeowners associations, this could also be the landlords themselves, but assist animals. If in fact I need my dog because I am blind, you have to allow me to have my dog. And we still have landlords who don't understand that. The homeowners associations get involved more along the lines of the parking spaces and the parking issues. They could have a requirement, for example, that no vans could be parked in the parking spaces, but they would have to allow me to park a van there if I was in a wheelchair and I needed the van for my transportation. The parking spaces have to do with the making of a handicap parking space for someone who needs it. So it's almost a given. I've never seen a case yet where the homeowners association or the rental community was ever successful in fighting this. The bottom line is if I come in and I need a handicap parking space, somebody just needs to get the paint out and make one because that's usually the way it comes down. So those are some of the issues. Steering, it's surprisingly enough, we're doing better with that. I mean, that used to be the biggest issue we had with fair housing was the licensees or the real estate agents presuming that they should take a buyer of a certain ethnicity or color to an area where that ethnicity or color was already living. I think we've kind of outgrown that one. I think for the most part that is not what we are having issues with, but that doesn't mean we should not talk about it. The issue of steering is a huge, huge problem if you're ever found in violation of it. So those are the issues with the conduct that's prohibited under the fair housing law, and it's something that we need to kind of reinforce with the students as we're putting them through the classes. The other couple of issues under the fair housing, the making property unavailable. Obviously, I cannot do that, but sometimes it's done a little more subtly. Making property unavailable could also include increasing the requirements. So if I said as a landlord that if you have children, I'm going to charge you a higher security deposit, that's a violation because families with children are a protected class if they under the familial status category. So I cannot charge a higher security deposit because somebody has kids. That's changing or increasing the requirements. And then the obvious of telling one person that it's available and another person that it is not. And I will say to you that the voice profiling has become an issue here, where just on the phone, when I answer the phone and somebody says, is that apartment available? And I listen to them and I presume they are of a certain group, I tell them no. And then somebody else calls 5 minutes later, and from their voice alone, I presume they're from a different group, and I tell them yes. Yes, there are testers that are sent out to do all of this. It doesn't make any difference if they're testers or not. If I violated the fair housing laws, I violated the fair housing laws. So it's an important concept that it can start with that phone call is the point. And it often does. The other exemption, I mentioned the Mrs. Murphy's exemption before. The housing for older persons exemption is absolutely in place. The only protected class in this case is familial status, meaning that if this is a 55 and over community, it was intended and occupied as a 55 and over community. And you also have the 62 and over, but we seldom in the real estate business get involved with 62 and over housing. It's the 55 and over housing that we tend to list and have buyers for. If it's intended to be operated and if it is intended and operated for 55 and over, at least 80% of the units are occupied. At least 80% of the units are occupied by someone 55 and over. Then, in fact, they can say no children. But they still cannot discriminate, or anyone selling property there cannot discriminate based on any of the other protected classes. It is only the familial status. But yes, that exemption is also still in place. So going over this with the agents when you're doing it, I will just tell you that we find that when I get the agents in the 30-hour post-licensing class or in the orientation program, that we as pre-license instructors have done a very good job of covering fair housing. So, and we should. It's an important concept. There's a lot of questions on their exam about fair housing, so it's something that we really need to make sure that we cover. So just make sure that you touching all the bases on that one. So that brings us then to a whole different section, and when you get to comparing your manual, if you will, with the PowerPoint, this is the one that starts on page 24. And this is all about the ownership of property and some of the definitions and how all of that plays out. So an estate is the degree, the quality. So an estate is the degree, quantity, nature, and extent of an owner's interest in the property. So, and they're all defined by estates. For example, you have a freehold estate. A freehold estate lasts for an indeterminate period of time. So fee simple is forever. A life estate is for the lifetime of the holder, but there is a period of time in which you own it, and that's a freehold estate. And most of the real estate in Illinois is sold under a fee simple. In other words, I buy it and I own it forever until I choose to sell it. You could have a leasehold estate, and that's what, it's a fixed period of time, and that's what the renters have, is a leasehold. But they still have an estate level in that property. They still have a right then to quiet enjoyment. They still have a right to do all of the stuff, as long as the lease allows them to do that. But they do have an estate level. It's a leasehold estate. And then we have the types of ownership. There are basically three types of ownership. Severalty. These are not terms that we use once we get out of pre-licensing, by the way. Once we get into the real world, we don't talk necessarily about this quite this way. How they're going to hold title is not something that we usually get involved with. But you can hold title by one person or by a corporation, and that's called holding title in severalty. You can hold it in co-ownership. That means that there are two or more persons that own that property, or it can be held in a trust, which means the trust it's a third party holding it for the benefit of another party. That's really the only three ways to hold title or hold ownership. Now, the forms of co-ownership are it's the co-ownership that has forms. You can do tenancy in common, and with tenancy in common, each tenant holds an undivided fractional interest in the property. They can convey their own interest. So if you and I both owned 50% interest as tenants in common, then I could sell off my 50% interest. It's unlike joint tenancy. Joint tenancy is right of survivorship, and I cannot then sell it off. Does that make, so there's different ways, and usually we've got spousal interest and all that other kind of stuff. Tenancy by the entirety, husband and wife have an equal, undivided interest in their personal residence. Right of survivorship, conveyed by deed, signed by both parties. One party can't convey one half of their interest to anyone else. So that's how we usually hold title as husband and wife in Illinois. And then gets all involved in the issue of community property. And it has to do with property that one of the spouses became owner of, and when they became owner of it. So if I came into the marriage with property that I already owned, It does not automatically give my new husband right to my property. If, however, I bought property while we were married, he now has ownership on that property. So it's not, in some states, they're called full community property states, which means that even if I came into the marriage with property of my own, the minute I got married, that property became half my spouse's. In Illinois, it doesn't work that way. However, in Illinois, if my spouse, who is not on ownership of the property, spent even one night on that property, in that property, as his marital residence, now he has to release his homestead rights. But he doesn't necessarily have interest in the property itself. The only reason this even becomes an issue for us, other than understanding, as you can see on that particular slide, the whole chart and how the property is held and how it is conveyed. We get involved with this because there are times when we sell property that we don't have the right signatures on the listing agreement or on the sales contract, because the idea here is, okay, Lynn owns the property. I see that she has title to it. Yes, but John, her husband, lived there with her for 6 months before they decided to sell it. Well, you still need his signature, because if he lived there as his marital residence, then he has to release his homestead rights. So making sure that the agents know who needs to release, even though we don't get involved in the ownership as much. So this is how, basic chart of how property is held in the co-ownership realm. The next issue relative to the conveyance of the property and the ownership is the legal descriptions. There's a couple of different ways that legal descriptions can be done. We can do a meets and bounds legal description, and that one relies on a starting point. So it could be a rock, it could be a tree, it could be a pipe in the ground, it could be a fence. And we say starting from here, and then we measure it all the way around, and then we come back to where we started. That's a meets and bounds legal description. It could be done with what's called a lot and block description. A survey is performed, it's platted, it's recorded, and this is what's used to plat and record most cities and villages. So we see meets and bounds descriptions being done in rural areas where there was no platting of the community. But in the areas where the communities were, we've got the surveys, we've got it all platted out, and we can look at a plat map and we can see where everybody is at. So it's going to be done, it can be done either way. And then there's the rectangular survey system. And we see this a lot, and that's what's done in Illinois for the most part. You will see on a deed, for example, or on a legal description, that it's the southwest quarter of the southeast quarter of the, and then it goes on to describe the legal description. So the whole issue here is that you're doing this from the 37 principal meridian lines in the United States, and each parcel is within that. Each one is specifically a number of acres, each one, and you can see the chart of how it shows, and this is what you own. The problem is that sometimes it doesn't fit into that little corner. Sometimes it doesn't fit into the box, so your legal description starts to be rather lengthy. The biggest issue here, after we get past the exam stage, which is that we have to know the rectangular survey system is the one that's based on the baselines and the meridian lines, we have to know that. But after that, what we need to know is who's reading the legal description on the transfer of the deeds to make sure that it is exactly what came through. Because if it doesn't read exactly the way it's supposed to, we have a problem. Usually the title companies take care of it, or the attorneys if they're involved, to make sure the legal description is correct. So those are the 3 different ways that we do the surveys. And it's going to depend on the part of the state that the property is in, and whether it's in a rural area, a municipal area, downtown Chicago, wherever it may be, on how all of that is going to be done. Now, so we plotted out we know how we're going to hold title. We know what the survey says, so we know what the property is. Now we have to look at, and we talked a little bit earlier about the types of deeds that we used. This is where these encumbrances, or what could cloud the title, can come in. First of all, a claim or a liability attached to the real estate, we call that an encumbrance. And usually the title companies will say that we're transferring title free and clear of any encumbrances. And that means there's no liens on the property. And liens can be, those are monetary things. It can be, there's going to be a mortgage lien on a lot of properties. There could be mechanics liens. Liens must be paid off or the property cannot transfer. A lien on a property keeps the owner from transferring the property to the next person unless the next person wants to accept the property with the lien on it, which they don't. So they have to be paid off. Now the mortgage lien is going to get paid off at the closing, but if there's a mechanics lien on there for work that was done to my property that I didn't pay the, let's say the roofer for the roof, we had that problem earlier, we didn't pay the roofer, he files a mechanics lien against my property. That property is, I'm not going to be able to sell it till I pay off the lien, or take him to court if the lien is not valid. It's not all that hard in the state of Illinois for somebody to file a lien on a piece of property. Pretty much you go to the courthouse, you file it, it's there. Are there some frivolous liens sometimes? Yeah, but usually a good attorney can get rid of the frivolity part of it. Then there's the physical type of encumbrance. That can be a deed restriction, an easement, or an encroachment. A deed restriction, there are still parts of the state where there are deed restrictions in there. And basically that's, somebody told me the other day that they found one. It's an old one, it's not still there. And the deed restriction literally said that they could not sell this property to anyone who was of German, they couldn't sell to Germans. They would not sell, they could not sell the property to somebody who was from German descent. You cannot have those deed restrictions anymore because they're illegal under the Fair Housing. But years and years ago we had them. There was another one that somebody mentioned the other day that said that you could not have chickens on this property, and that was a deed restriction. And one of them that we were just having a class and everybody was bringing them up. You couldn't hang your laundry out to dry. Well, when was the last time you saw anybody hanging their laundry out to dry? Not that there's a problem with that. I happen to like to hang my laundry out, but there could be deed restrictions for some of that kind of stuff. Easements, yeah, I would venture to say that you've got a better than 50% chance that almost every property, at least the properties where they are, 70 by 120 foot lots in the middle of, let's say, Schaumburg or someplace like that, there's some kind of easement on there. There's an easement for the utilities. There's an easement for something. Those are and the issue with easements is whether or not you can build over the easement. Some of those easements you can put fences on because they can remove the fence if they need to get access. There are other easements where you cannot build on it, and most of the time you cannot put any permanent structure over the easement. So the easement on a property could absolutely restrict how much of the land you can build on or actually utilize to do anything other than just plant grass, seed, and mow. Okay. And then we sometimes have encroachments. Encroachments happen when, in many cases, when the builders built a subdivision, they didn't pay enough attention to the lot lines. And we'll have a driveway that's encroaching by maybe 6 or 7 inches into the next property. Sometimes when fences were built, if they didn't do a survey for the fence, they put the fence onto someone else's property. Two choices at that point: move the fence or the driveway, or have the title company insure over the encroachment. It usually, unless it's a huge problem, doesn't, or a huge encroachment, doesn't pose a huge problem. The other issue are water rights. Water rights can be restricted by state and federal law, and often they are. You have two different kinds of water rights, as you see on your slide. Riparian is along a river or a stream. Littoral are lake, ocean, or sea. So for the most part, we have riparian rights in the state of Illinois. We're not dealing with oceans. We're not dealing with seas. The only place we see the littoral is up in the, anywhere around Lake Michigan. For the most part, it's, I mean, I know we have other lakes, but for the most part, we're dealing with the riparian rights. The only thing we need to worry about here, other than the definition so we know, is that it can be regulated by the state or other laws. For example, up in the Chain of Lakes area, just because you're on the water doesn't mean you can have a pier, because they're regulating how many boats are up there, And they're doing that by saying whether or not you, and how far out into the waterway that pier can go. So just because you're on the water doesn't give you 100% right to the water. So after we've done all of that, we know what we're buying, we know what we're getting, we're going to get clear title, all of that, we have to finance this. So the financing side of the transaction, basically we've got, 4 different kinds of loans. You've got a conventional loan, and a conventional loan is really, it can be done by a big bank, it can be done by, it's a Fannie Mae backed loan, a Freddie Mac backed loan, but it's a conventional loan, as opposed to an FHA loan or a VA loan or a rural housing and community development loan. So at any point in time, which type of financing works better for the buyers is really best left up to a lender, unless you have community development funds available, but then you have to go to a lender that's handling for us, the IDA funds, for example. Only specific lenders have the ability to do that. So it's our job then as real estate licensees to know where to go to get the types of loans, but it's the loan officer or the lender who's going to say to the buyer, based on their credit score, based on their down payment, based on a ton of things that we don't get all that involved in, which type of loan they're gonna go for. One of the things we do have to be aware of, and we do have to make sure we explain to the buyers, is the issue of whether or not they're going to have to pay mortgage insurance, PMI, private mortgage insurance, or MIP. MIP is what goes on the FHA loans. PMI is what goes on the conventional loans. But typically, if the buyer has less than 20% down, they're going to have to pay some type of mortgage insurance to insure the lender for the difference between 20% down and what they actually have as a down payment. Otherwise, the lenders won't make those loans. So does a buyer have to have 20% down? Absolutely not. Buyers can buy houses with 3% down. There's ways to do it, both conventionally and through FHA. But they will be paying a little bit more in a premium. In other words, it's just like anything else. And there's people who go, well, I don't want to do that. I don't want to have to pay that premium. Well, then go save 20% of your down payment. If you don't have the 20% down, it's no different than if you don't have a high credit score. Might the financing of your car be a little bit higher because you're having to pay a higher interest rate because of your credit score? Yes. Well, this is kind of looking at your credit worthiness, giving you the ability to buy, but you're going to have to pay a little bit of a premium. Fannie Mae and Freddie Mac are absolutely involved in what's going on in the financing side of the real estate business. They're the ones who are going to insure those loans. Each program has its own requirements. Those requirements change frequently. Thank goodness they're not putting anything in our pre-licensing exams about what's going on with Fannie or Freddie or interest, all the rest of that. Years ago they used to, and we said you can't because that can change on a dime. And even as we speak right now, while I am making this for you, this video for you, we are looking at, within the next few months, a sea change, a game changer when it comes to how we're going to be handling all mortgages in this country, due to changes coming from the Consumer Federation Protection Bureau. So depending on when you're listening to this, it may have already happened. So if it has, then you know exactly what I mean. It was a game changer. So we're not going to spend a ton of time here, and in pre-licensing class, basically you need to do the same thing. What is going on, but not get bogged down in it. Just explain to them what Fannie Mae is, what Freddie Mac is, and why it's so important for them to know what's going on. So they know what programs are available, they know what the requirements are, because they do change those requirements periodically. So now we've got it financed, but now we've got some other things that could happen, and that's our real estate taxes and the liens issue. So a real estate, we've got voluntary and involuntary liens. All right, a voluntary lien, for example, is my mortgage. When I take out a mortgage on my property, what it means is that I sign two things. I sign a note and my mortgage. My mortgage is the note is what I'm signing to pay back my mortgage. So this is my mortgage and this is my note. They're going to record that mortgage so that I can't sell the property and not pay them off. That's a lien. So the minute I have a mortgage on my property, I have created a lien. So the mortgage lien is filed by the lender to secure the note. The note was what I'm promising to pay back. Now you have involuntary. You have some that are what's called statutory. Those are created by law through no consent of me, the owner. So a tax lien for non-payment of my taxes is statutory involuntary. I didn't want them to file a tax lien against my property, but if I don't make my tax payments, they're going to be able to do that. And then we have what's called an equitable lien, and that's a court order to satisfy a judgment. So an example of that is a mechanic's lien. That they had to go to court, they had to get a court order, and the court said, yes, you can put a lien on Lynn's house because she owes you that money. So that's called an equitable lien. A statutory one is created, if you will, by usually the state or federal. Well, absolutely federal could, because if I don't pay my income taxes, they can also put a lien on my property. And a lien remains on the property unless satisfied, and can affect the ability to transfer the title, as I said to you before. The liens are usually prioritized in the order in which they were filed. So if my property then, my property was taken from me, then they're going to pay off those liens in the order they were filed. The exception to that is tax liens have a priority. So you have the priority on there of the tax liens. And then the issue of whether or not we can lien property as brokerage companies. And in the state of Illinois, we cannot on residential property. So the only time we can put a lien on property for our commission is if it is a commercial piece of property, and that lien has to be filed prior to the closing. So, but on a residential property, there are no lien rights on the brokerage companies for our commission. That's not allowed. So that's how the liens work. So that kind of wraps up our whole conversation, taking us from and I know when you go to compare this with what your outline is, I moved things around a little bit to give us some good kind of flow to the material. So you're going to have to look around a little bit if you want to compare apples to apples. But that kind of took us through the process of how we got the property, how we finance the property, what happens to how we transfer the title, how we do the liens, and all the rest of that stuff. So let's move on then to section 9 in your manual. Starts on your page 60, and this is the land use controls. So we want to talk a little bit about land use. I mentioned it earlier when I mentioned that I have the right to pretty much do whatever I want to with my property, but it has to comply with whatever the municipality, for the most part, has said I can do with my property. So those are zoning ordinances in most cases. Counties and local municipalities have them. There is no Illinois zoning ordinance. It's going to be done mostly by local municipalities. It's permitted use of the land. Whether it's residential, whether it's commercial, whether it's light industrial, what can I do with this property? It's lot size. They certainly can say that have to be half-acre lots or quarter-acre lots or one-acre lots. That can be dictated. The density, meaning, and I'm not going to mention specific areas, but I remember it was a community I used to sell in, and I'm saying was a community, they still could have the rules, I don't know, but you cannot cover more than 30% of your lot with any kind of permanent structure. So that means that's going to create a density issue when it comes to, I've got a quarter-acre lot, how big can my house be? So it's my house plus my driveway. I can't cover more than 30% of my land with those structures. That is not a bad, and everybody goes, you have no right to tell me what I can do. Here's the issue. You cover too much of the earth that soaks up the water with driveways and houses and sheds and all the rest of it, you're going to have flooding. No matter what you try to do, you can't just continue to make everything what? Cement. So there's reasons for land use, and the reasons for land use are usually to ensure that property values stay up. And if we understand the whys for some of this, it does start to make some sense. The types of structures that you can put in there, and sometimes this also goes to homeowners associations. So if you live in I lived in a homeowners association in a town, I'm not going to mention it, 1 acre lots, and they had weird requirements like none of our roof lines, none of our roofs could be covered with typical shingles. They had a very specific list. We had to wood shake shingles. We could use all kinds of other things, but they didn't want any of the houses in this, I'm talking a town now, this whole area, we could not put anything other than fancy schmancy roofs on there. No front-loading garages. They didn't want any garages facing the street. So if you left your garage door open, I guess they didn't care. They just didn't want anybody to see it. They all had to be side-loaded garages. We also had a restriction of we could not park our cars on the street at any time, anywhere. So this was not a matter of only parking on the left side or the right side of the street between this time and that time, or no parking during these hours. There was no on-street parking at any time, to the extent that when a landscaper came to do our landscaping, they could not leave their landscaping trucks on the street. They had to pull them into our driveways. Now, we were on 1 acre lots with side-loaded garages, which pretty much tells you that every one of our driveways was pretty lengthy in and of itself. If you think about trying to get a side-loaded garage, 1 acres, then you also had setbacks. How far back from the street can you build this house? How much from the side can you build? There can be setback lines. All of this is extremely important when we are selling houses, and the agents need to understand how all of that works, because we can't just be selling a house and saying something like, oh, don't worry about it, you'll be able to put a 3-car garage back there. Because I might not be able to put a 3-car garage, because I might not be able to cover any more than 30% of my lot with structure, or a 3-car garage would not meet the setback lines. So all of this is stuff that the agents need to be aware of. And I know there's times where everybody goes, well, why are we teaching them all of this stuff? Because these are the things they need to be aware of when they get into the real estate business. So zoning ordinances can absolutely have an effect on how we do this. The categories of real estate in Illinois are residential, commercial, and agricultural. And we've talked about residential and we've talked about commercial. Within those 3 categories, however, those 3 big categories, you have the smaller ones. You can have R1, for example, which is often R1 is residential 1, single family. R2 could be condos and townhouses. R3 could be rental properties. So there's different categories within each one of those, and certainly within agricultural, you've got all kinds of different categories, but those are the 3 basic. And then you have the issue of private land use controls, and that's your homeowners associations. I mentioned it a little bit earlier about a couple of other things, but they have a lot of control now, not only of what you build, but what you do with it. So when selling property that has a homeowners association, it's important that the agents make sure their buyers see what's called the CCRs, the covenants and the restrictions, and the rules and regs when they're purchasing in a homeowners association. Quick example you can use is this. Buyer has a boat, and the buyer wants to be able to trailer his boat all summer, going to different places with it, and park it in his driveway all summer long. Could there be, in either a zoning ordinance from the municipality or from the homeowners association, a prohibition against parking a boat in the driveway for more than 24 hours at a time, or any other cockamamie thing? And the answer is yes, there can be. So it's important then, if they've got step vans, if they've got any kind of large trucks, if they've got whatever, they're going to have to either try to get an exception to that, which they're almost never going to get, because you give an exception to one person and pretty soon the whole subdivision looks like a boat parking lot. It's why sometimes our buyers buy in unincorporated areas, because they don't want to have all of these restrictions. For the most part, townships and counties don't put these restrictions out there. These are done by local municipalities. The counties might, but seldom do they put the, you can't park a boat here. Those are going to be done more by the homeowners associations or by the municipalities. So the land use controls can be an issue. So that's the pretty much what we wanted to cover. There's a couple of other sections in here that I did not spend a lot of time on with you. Property management, for example, you can read through that on your own.